There's a patent guru on YouTube who's claiming if your goal is to license your patent, all you need is a provisional patent. And getting a full patent for that purpose is a waste of time and money. Agree or disagree? Well, I disagree. I disagree on many fronts. I have a hunch as to who I think this guru might be. But I will say that if your goal is to license your patent, you need to actually get a patent. Okay, so to get a patent granted, you do have to file a non-provisional, or i.e. the full patent application, which will then get examined. The USPTO examiner does their own search, gives it that thumbs up, which is known as the notice of allowance, and then you pay the issue fee and get the actual federal rights granted. That's when you get the patent number and so forth. That is what is being transacted in a licensing agreement. Now, there are licensing deals that can happen with pending applications, but that word application is really vital. In this question, I'm concerned already because you're asking, all you need is a provisional patent. There is no such thing as a provisional patent. There's a provisional patent application. And a provisional patent application is one that's less formal, doesn't require a lot of the rigor around the declarations, the disclosure of invention or known prior art, as well as the detailed description of drawings, and a lot of the figures and the claims being in the specification. It can really just be a description of your invention, and you can include drawings if you want, and they can even be hand-drawn. They don't need to have any specific format or function. And so it's quite easy. And a lot of inventors will be able to learn enough about patent law to be able to file a decent provisional on their own. And so for a lot of bootstrapping entrepreneurs, I think it's a great option for you to file something. It's better than not filing at all. And that's what the USPTO, the Patent Office, and the policy would actually prefer. We want innovators, inventors to tell the world, right, to file your application as soon as possible. That's why the law changed about 10 years ago. It's no longer whoever invents it first, it's whoever files it first. And so we want to reward inventors to file. And so that's why the bar is really low in terms of the technical competence and sophistication needed to file a patent application at the provisional level. But the problem is there's no federal grant. You have no rights that are granted when you file a provisional patent application. So it's really vital that you understand that. Whoever this guru is, I hope that they're clarifying it. The fact that you're asking this question in this way tells me that maybe they're not hitting that home, that you don't get any rights by filing a patent application. It's pending. And a provisional does not even get examined. So it really is just this placeholder. You could file a provisional application that says, "Hi, I'm JD," and that's the entirety of the spec. And yeah, you would get a pending application number, but there no one or no company would be willing to compensate you, the inventor, for that statement. It doesn't describe any invention, and it's not valid. So long story short, there are certainly ways to get patents licensed, but in order to get a patent license, you have to go through the process of filing a full patent. So certainly not a waste of time. That is how patents are granted. So I would disagree with that.